The President, please be seated. The President. May the Defense Council continue their statement. Thank you.
Good morning, Mr. President. Good morning, Your Honors. Good morning to everyone in and around the courtroom. Let me briefly pick up where my colleague left off. And just note, considering the co-investigative judge's assessment concerning house arrest, where they simply make a statement, but they actually make no reasonable attempt to lay out any of the reasoning behind it, how they arrived at their conclusion. They simply state that house arrest under no circumstances can equal detention as in the prison facilities here. And I think that's axiomatic. A prison is a prison, a house is a house. The only difference that we're suggesting here is that you have a guard outside the house. But no house can ever resemble a prison facility, because in a prison facility you have somebody telling you what you will eat, what you will drink, who will visit you, when you will get up, when you will go to bed, and so on and so forth. So that's not the real question. The real question is whether conditions of house arrest would protect the objectives of to an acceptable extent that are laid out under the rules, under Rule 63(3)(b). And we submit, and we have submitted in our both in our written submission, and today my colleague, Mr. Angodom, has indicated that we quite clearly show that Mr. Ieng Sary is old, he's sick, he can barely make it to the dock over there without assistance, and somehow the suggestion is that he is going to be fleeing away. And as I've indicated, the OCIJ made absolutely zero attempts to analyze how it is that house arrest doesn't meet the criteria that would enable and ensure that Mr. Ieng Sary is present if and when trial proceedings begin. So I don't want to dwell on the point, but suffice it to say, I think it puts the defense at a reasonable disadvantage to try to opine as to what was in the OCIJ's mind when they deliberately attempt to prevent the defense from poking holes into their reasoning. They simply make a statement. We said it, therefore it must be so. But let me move on to the next segment, which deals with the issue of due diligence. And as was pointed out during the initial presentation on the procedural history of how we got here thus far, it is quite clear that we maintained that the investigation is rather slow, it's rather incomplete, and we will be filing submissions suggesting that it is not even properly being conducted. But that's neither here nor there for today's presentation. But if I could just a moment go back to the health issue and to suggest the issue of due diligence and the fact that the OCIJ is seized with Mr. Ieng Sary. They are master of life and death, if you will, concerning Mr. Ieng Sary while they are in this investigative stage. However, it is very clear that once Mr. Ieng Sary goes to the hospital, they lose complete control of Mr. Ieng Sary because the hospital determines what the rules are. They disregard orders by the co-investigated judges. They disregard any orders from the pretrial chamber. And we are in a position, as his lawyers, not to have access to his full medical history. We don't know who all his lawyers are. We do know from the good doctor who is over here that there is this committee. But we dare say, if the OCIJ is going to seize Mr. Ieng Sary and control who he sees, what sort of medication he receives, who are his treating physicians, whether he will be tested, then the OCIJ needs to share that material to the defense so we can be due diligent in in the function that we fulfill to make sure that actually tests are being done, the right ones. And of course, it's regrettable that we didn't have the opportunity to hear Dr. Falk, because he would be able to tell us the sort of testing that is expected to take place once an accused is before the United Nations detention facility, detention unit in The Hague. So we do maintain that for some reason or other, this issue of health will continue to be on the forefront and is part of the due diligence. Why are we unable to have these medical reports? Why are we unable to see whether he's getting the proper medical treatment? Obviously, we cannot order an independent evaluation because the OCIJ is seized with Mr. Ieng Sary. We cannot order that a psychiatric evaluation be done because that, again, is up to the OCIJ if and when they feel it is necessary. So we believe this is part and parcel of the fair trial rights that Mr. Ieng Sary enjoys, in which I was pleasantly surprised to find in the prosecution's recent submission, where they quite eloquently state, and rightly so, because that is the law after all, and when they are right on the law, we will commend them publicly and repeatedly, that the fair trial rights apply throughout the proceedings, not simply at trial, but even at the pretrial stage. And so we commend them, and we believe that part and parcel of the fair trial rights is the right to take care of an individual who is in custody, and when the custodian decides, or is the decision maker, I should say, as to the sort of health and well-being of that individual. Now, let me move on to the other issue, which is perhaps the more problematic issue with due diligence, because we maintain that the investigative process has not been carried on sufficiently, speedily enough. The quality, as I said, we will deal in another time. But most recently, and this is part and parcel of this issue that was raised, most recently we see that there is an ever-growing issue concerning corruption in the courts, in the administrative section. And it's not something that can be taken lightly. And I will exactly tie it in to show the nexus between due diligence and this issue. But we had none other than the highest UN official, Knut Rosenhag, state that the chief administrator of this institution, Sien Visot, has been implicated in a report issued by the German government based on representations made by Knut Rosenhag. These are the reports that the German delegation made.
The President, the defense, the lawyer, please.
May I have your indulgence, Your Honor? I don't mean to interrupt my learned friend's arguments. But the two issues, the issue of health and the issue of corruption, do not lie within the four corners of this appeal that my learned friend has filed. The issue of health has been disposed of by Your Honors in 4 applications that were dismissed And Your Honours were pleased to hold on the 30th of March, just 2 days ago, that health issues do not squarely arise substantively in this appeal. Secondly, the question of corruption was nowhere raised, nowhere argued by my learned friend before the investigating judges. Therefore, they were not in a position to dispose that of. And as we speak, it's public knowledge that an application to go into the question of corruption is before them. So, Your Honours, it would not be appropriate for my learned friend to dwell on these issues that are sub judice before the court below. This is my submission. And the health issue, as I submitted, doesn't arise in the facts of this case. I apologize for this intervention.
And as I expected the interruption from my colleague, who makes the habit of interrupting rather than making his submissions when his turn comes, let me just tie in why it's relevant. Because 2 days ago, you had the Prime Minister, Mr. Hun Sen, indicate quite clearly that he was disappointed with the Japanese government providing $200,000, I believe it was, for the payment for the salaries, which met half the salaries of the Cambodian staff. You have this corruption issue that is front and center. Donors are shy to come up and step up to the plate to make contributions. And why is this important? And it ties into our due diligence aspect. Because we don't know if 6 months or a year from now, this institution will be present, will be functioning.
I believe you're not responding on the interruption made by the co-prosecuted, and you're allowed to do so, and then we'll deliberate whether we allow you to continue.
And while I was, Your Honor, responding with all due respect, because I believe it's part and parcel of the issue. The budget, the corruption, whether we will be here, if the investigative judges are not conducting their investigation in a due diligent manner, and if the institution is likely not to be in existence 6 months or a year from now, then I dare say, with all due respect, this is a consideration for the pretrial chamber to take in determining whether an individual should continue to be detained when it's the likelihood of this institution being able to deliver the impartial and independent justice that it is set out, and whether it has the funding to continue. And that's why we believe this.
Thus, the pretrial chamber has to understand that the reasoning you're providing now is part of the due diligence reasoning which you put in the appeal?
That's correct. That's correct.
Okay.
We believe it's part and parcel. The due diligence has to do with the investigation. If the investigation is slow, and now with this corruption, because we have an application for the investigative judges to investigate the corruption within this administration, not for the purposes.
Perhaps, before you continue, I would like to have the co-prosecutors respond on the response you gave that this is part of the due diligence reasoning which you provide in the appeal, because, as I understand, the co-prosecutors say that the reasoning you're providing now is not part of the appeal.
And if I may be allowed just 30 seconds of indulgence to finish my thought, what we're suggesting is, because now the co-investigative judge will need to do an investigation to see what, if any, parts of their investigative process has been tainted, that means that the conclusion of their investigation will take even much more longer. So if they're not being able to be due diligent at this point, how can they be due diligent when they have to have this extra burden of looking into the matters, not for the purposes of prosecuting a wrongdoer, but for the purposes of seeing, and we will be able to show to what extent, if any, the evidence that has come before them or the efforts that have been made that they're going to be relying on in making their decisions at the end has been tainted. And we will be insisting that an investigation be done by them for those purposes. And I don't think that they can certainly shy away and say this is somebody else's burden. They have the burden because it's the OCIJ that has the obligation to ensure that the investigative process is fair. And what we're saying, that this will complicate matters. That's why it's part and parcel of the due diligence argument. And I hope I was clear, Your Honor.
Will the co-prosecutors respond?
Your Honor, it's an appeal of 19 pages, and the word corruption doesn't arise even once in this appeal. As a matter of fact, it's a different charged person before you, Nunchia, who has raised this matter before the co-investigating judges on the 26th of March, which my learned friends for the first time have joined in the form of an intervention application, joining with Nunchia in respect of that argument before the investigating judges. No application, to my recollection till today, filed by my learned friend, has raised the issue of corruption before this court. So in this appeal of 19 pages, not a word of corruption. And I draw your Lordship's attention to 75.4 of the internal rules, where in February 2008, all of your Honours sitting in the plenary decided that the appellant may not raise any matter of fact or of law during the hearing which are not already set out in the submission on appeal. So my respectful submission is, this was never raised, and in any case, on this last date of hearing, when your Honours are finally disposing of an appeal, my learned friend could have given us an indication even yesterday by an email that this issue is being raised. We could have responded. Your Honours would recall in the Q Sampan case on the 20th of October 2008, you very correctly said, and I quote, if your Honours permit me to read that, and just one sentence, the pre-trial chamber finds that the defence is barred by Internal Rule 75.4 from raising additional matters of fact or of law at this stage, at the stage of the hearing, the final day of the proceedings, which are not already set out in submissions on appeal. That's my most respectful submission.
If I may just very briefly respond. As I've indicated, it's part and parcel of the issue. Now, whether new developments have arisen, that's another story. Only 2 days ago, who could have predicted that Mr. Hun Sen would have made the remarks that he did in fact make, which again calls into question whether this institution will be in place. We believe that all of these facts are tied into the due diligence issue, because the question that we've raised in due diligence is that it is taking so long, and when the process takes so long...
I believe then that you're repetitious now, Mr. Canavas, and I only allow you to respond on the remark made by the co-prosecutors that it was not announced before this appeal.
Well, because we don't see it as new facts. We see it as part and parcel. And if we look at the decision on appeal against the provisional detention of Mr. Ieng Sary on the 17th October 2008, on paragraphs 68 and 69, but 69 in particular, you do indicate that in deciding if the grounds for provisional detention as set out in Rule 63.3 are met, the pretrial chamber has taken into account the written pleadings of the parties and their oral submissions, the evidence they have submitted on the record, that this matter was indeed filed on the 26th, as my learned friend indicated, by the Nunchia, and we commend them for taking the lead on this issue. We then joined in on their submission and adopted in whole, unreservedly, all of their submissions, and sadly enough, to this date, days later, it is not in the co-investigative judge's, it is not in the case file. However, that calls into another question that we have raised in the past. Why does it take so long? But we maintain it is out there, they're aware of it, it's part and parcel of the issue, and therefore we're relying on what you've indicated here on paragraph 69 to suggest that since this is part and parcel of the issue of due diligence, we're not raising new facts. The issue of the budget, if the co-investigative judges have less money to conduct their investigation, it's going to be prolonged.
Mr. Canavas, you're going into the matter again.
Well,
this was about the intervention, and you were allowed to respond on the issues raised by the co-prosecutor, and I believe you did.
Thank you very much, Your Honor. And I apologize if I'm being a little bit disputatious.
Mr. Cannabis, we will permit you to proceed on the basis of discussions concerning medical issues, but no other issues in respect of which you have not given direct notice. So there will be no discussion about issues of budget and issues of corruption. They form now the basis of other applications which are before this court.
Thank you, Your Honor. With that ruling, I believe that the issue of health and care and the ability for the lawyers to have access to Mr. Ieng Sary and for the hospital to comply with the issues of the OCIJ or the pretrial chamber, I believe we have sufficiently covered them. And in light of your ruling, because we do believe that the issues that that the matters that I raised, which are part and parcel of the issue, cannot and should not simply be ignored because we may be giving the wrong impression perceptually. And even though these matters have been seized for a different purpose, it would be our respectful submission at this time, Your Honor, that the proceedings continue to what has already been allowed thus far and argued on behalf of Mr. Ieng Sary thus far, but that, as I understand it, you will return in June. We could have a continuation of this hearing, in other words, not make a decision, and allow the prosecution to have sufficient notice, although I'm quite comfortably sure that they are well aware of what is going on, but that would give them sufficient notice, because we do believe that the issue of whether the investigation will take on a life of its own and take an extended period of time, or whether there will be an insufficient budget for this institution to be around at some point, we do believe these are issues that you must consider in determining whether Mr. Ieng Sary should continue to be at the detention unit over here, or whether a less restrictive measure such as house arrest be issued, which would ensure that he's available if and when the trial, the investigation is completed, and depending on that, those results, whether a trial is going to commence. So that's why we believe that these are relevant issues or relevant developments in this issue of due diligence. We do believe that it's taking a long time for this individual, and we do believe, and as I made my argument last time I appeared, that detention should not be a form of punishment. It should not be viewed as a way of getting a sentence out of someone prior to trial, especially when perhaps his health is precarious and perhaps he may not be around for the trial, so at least there may be some satisfaction by some that at least a very few years of his life were spent in detention waiting to be trialed, having been branded as a criminal and having been essentially tried and convicted in the court of public opinion as a criminal for the crimes for which he's being investigated at this point. Because we do believe, in spite of what we read in the press or in spite of what we know from reading the history books, he has certain rights, and those are the rights to be presumed innocent, the fair trial rights which the prosecution so eloquently put in their last motion, which are based on and ingrained in the Cambodian Constitution and part of this institution's rules. So with those submissions, Your Honor, I have nothing further at this point in time, and I appreciate your indulgence in allowing me to at least articulate the reasoning behind. I understand your position. I accept it. However, I felt compelled that, at least in my interpretation, that this was an issue that's part and parcel to the issue that we had raised, and that's why we raised it at this point in time, and we appreciate, again, the indulgence that you have shown and the time that you have given us to have this hearing. Thank you.
The President. May I invite the co-prosecutors to make their oral submissions. You have 1.5 hours. The floor is yours. Deputy Co-Prosecutor. Mr. President and Your Honors, in the names of the co-prosecutors of the extraordinary chambers in the courts of Cambodia, in support of the provisional detention of the charged person Ieng Sary, on behalf of the prosecutions, I would like to make the following submission. Due to the brutal and inhumane nature and gravity of the crimes committed by senior leaders and those most responsible during the period of the democratic Cambodia on the innocent Cambodian people, and in order to find justice for those victims, with a commitment to eradicate the practice of impunity in the Cambodian society, the Royal Government of Cambodia and the United Nations agreed to establish the extraordinary chambers in the courts of Cambodia to prosecute crimes committed during the period of democratic Cambodia from 17 April 1975 to 6 January 1979. On the 10th July 2006, the Office of the Co-Prosecutors of the Extraordinary Chambers in the Courts of Cambodia commenced its mandate and conducted preliminary investigations into the crimes committed during the period the Democratic Cambodia was in power. On 18th July 2007, the co-prosecutors submitted an introductory submission in which Ieng Sary was one of the 5 suspects to the investigating judges and requested them to arrest and detain Ieng Sary provisionally and the other 4 suspects for the purpose of judicial investigations. After some months of investigations, the charged person Ieng Sary was arrested and brought before the tribunal by the arrest warrant of the co-investigating judges dated 8 November 2007. On 12 November 2007, the charged person Ieng Sary appeared before the co-investigating judges. Subsequently, the co-investigating judges issued a provisional detention order for the charged person Ieng Sary, dated 14 November 2007. The charged person Ieng Sary was charged with crimes against humanity and grave breaches of the Geneva Convention, dated 12 August 1949. The crimes defined and punishable under Articles 5, 6, 29 new, 49 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, dated 27 October 2004. We all know that severe crimes are punished internationally, including crimes against humanity, genocide, and war crime. The international community has been anxiously expecting the charged person who has seriously violated the international criminal law be brought before the court for prosecution. Although it is imperative to balance the fundamental, there are other necessary factors which other courts have to resolve and decide for crimes which are the concerns of the international community. Mr. President and Your Honor of the pretrial chambers, the decision to extend provisional detention for the charged person Ieng Sary has been objected by the charged person and his co-lawyers, and subsequently they made an appeal against the extension order for provisional detention in the appeal dated 10 December 2008. Today, before the chamber, the charged person Ieng Sary and his co-lawyers still The defense counsels, Your Honor, may the chamber allows Mr. Ieng Sary to rest because he can no longer sit and we can continue the proceeding without his presence. Mr. President, he is allowed. The President, he is allowed to rest.
And just for the record, Your Honors, this is with his consent. In other words, he's consenting to be absent. So I just want to make sure that it was very clear on the record. Thank you.
So, the President, the prosecution may continue the statement. Deputy Co-Prosecutor. Today, before the Chamber, the charged person Ieng Sary and his co-lawyers still maintain their position on the appeal and request the pre-trial chamber to reverse the extension order for provisional detention dated 10 November 2008 by the co-investigating judges and request the pre-trial chamber to issue an order to modify the conditions of provisional detention from the detention facility to house arrest and the strict and necessary conditions imposed by the pre-trial chamber. The co-lawyers submit that requirements of detention in Rule 63(3)(b) are not met. The co-investigating judges failed to exercise due diligence. The fundamental rights of the charged person Ieng Sary were not sufficiently observed and no other alternative modes of detention, such as house arrest, were considered. The co-investigating judges have not exercised due diligence in conducting their investigation since this charged person's arrest in November 2007. On this matter, the prosecution would like to submit that the co-investigating judges have an obligation to issue an order for the extension of provisional detention if deemed appropriate. However, the co-investigating judges are not obligated to present additional evidence in the case filed to support their decision in extending the provisional detention. It is apparent that in the case filed of the accused of the charged person Ieng Sary, the evidence has increased both in volume and gravity. However, in the appeal, there are numerous mentioning that the co-investigating judges failed to exercise due diligence and the fundamental rights of the charged person were not sufficiently respected, and that the co-investigating judges failed to add additional evidence to the case file in order to support the extension order for provisional detention. Moreover, the co-lawyers submit that the co-investigating judges completely ignored the request to examine the aforementioned issues that were raised. The submission by the co-lawyers is therefore inappropriate.